definition on unforeseen circumstances. Tomorrow is a case before the state Supreme Court regarding the burials with the EV. The case being that the archaeological inventory survey should have been done all at once, so the taxpayer knows what they're going to be up against if there's mitigation in the cost, that an EIS, all that should have been inclusive at the forefront, not piecemeal. So that case being tomorrow, in the event that it's adverse and not in favor of what HART would like to plow through, does it all come from the contingency fund of the 800-some million in there, that each court case, that if in the event that the HART would lose, or city attorneys defending HART would lose, that would come from the contingency fund and not be of party to this line of credit because it couldn't be deemed as a unforeseen circumstance? Is there a definite definition there that separates court cases and the fallout from such from the line of credit?
I think we have, first of all, I think we have a high degree of confidence in the case. Secondly, the funding that you're talking about, the trigger that would have us coming before the council for the MOU and then for request to complete the city and county's project is one where we wouldn't have resources. So right now, I assume if there was some other action by the court, that that would be something that we would be liable for within the funding that we've got. So we wouldn't be tapping this money.
So you'd be depleting the contingency fund.
I guess I'm not exactly sure the source of where our litigation.
I'm going to reference your letter dated May 8th, and it's a response to Councilwoman Gabbard's request at the April 30th Legislative Matters Committee meeting on this very subject, and it has to do with the completion of the AIS by a certain date, January 2013.
Right.
If the phases from Kiwi goes from phase 1 to phase 2 without any duration of a lapse, and they just go into the next phase, in the event that there was to be a decision by the state Supreme Court, I know you're confident, but in the event there was to be a decision, the ramifications of just attorney's fees and doing an EIS by completed and pushing that back, we understand that to build rail and tear it down is going to come into play. So let's assume that we just, I know you don't like hypotheticals, but if you were to deplete that $800 million in the contingency fund, because there's another lawsuit and there's another lawsuit. You got Bombardier, and then you got the Cayetano suit with the others, HonoluluTraffic.com. In the event that those are successful, and you deplete the $800 million, can the unforeseen circumstances be such as this? Could you trigger and tap into this line of credit in the event that you're batting 0 for 3?
Yeah, I don't think that, well, again, it would be what each of the judges ruled in each of those cases that would dictate, I guess, the very future of the project.
There'd be a delay. And the delay is going to cost the taxpayer. And you gave us that.
So I think we'd have to cross that bridge when we came to it.
But you know what? That's my question, Chair. Is I want to know now if the line of credit will be of party or used or requested thereof in such circumstances that any of the three litigation of such suits are in adverse to HART's position. Will it be allowed in the MOU, MOA? Will there be any language in there that says, hey, that's an unforeseen circumstances, and you council members, you didn't ask. So I'm trying to get it in the minutes for clarification, Chair.
I don't believe that would be the case. And again, as was mentioned earlier, even if there are unforeseen circumstances, but the GET comes in over the next, 9 years above and beyond what people expected, that's where we go first. And so this is required of the FTA to have this additional commercial paper only in the event that there's some unforeseen circumstance that arise, probably typically near the end of the project, and there's
that's where the EV. Sorry to interrupt you, but that's where the EV are content. The case here is that when they get to Kaka'ako, is that the reason we're moving forward on phase 1, Chair, is it's because we don't know. I'm not doing the archaeological inventory survey. January 2013, court case tomorrow. In other words, come to the council, ask for the 350 million up to the debt ceiling, and not know. And that's the whole point of this case tomorrow, is that the public should know. The public should know when you get to Kaka'ako, what if that will indeed be an unforeseen circumstance. You have answered my question by saying no definition if it will or will not trigger. An unforeseen circumstance could or could not be involved with the court case inclusive. The answer is I'm still going to walk away not knowing.
Well, probably not in 2013, because again, there'd be still sufficient GET funding going forward till 2022. So I wouldn't see that as I wouldn't see that, actually. Again, but the hypothetical is difficult to answer because whatever the judge might rule could be, well, they could rule in any way on each of those three cases, so.
I'll save my comments for the discussion period.
Okay, thank you.
They've already compromised this project because it doesn't pan out. It's not sound. It is Swiss cheese. This whole project never panned out the moment they passed Act 247 at 0.5% that this council approved. They knew back then you needed 1%, and this has been nothing but a backdoor to make rail work, fit a watermelon through a hose. It's just not working. Members, let's go back and say that the voters and the public wants the essentials. They really want the essentials. They want to go back to fixing the roads, the sewers, the water mains. That's what they're after. This diversion of saying of a line of credit, because the FDA is requiring this language, the antecedents to that is because the financial plan isn't sound. Whether it's a debt service, raising such. If we just focused on a GET surcharge at 0.5%, and just focused on the fact of whether or not it's going to be bonds and paying back the interest at 4.25% on the bonds, and we just looked at that with the federal monies of hopefully of a $1.55 billion, now you're banking on the fact with the 3 lawsuits you're going to win all 3. We'll know maybe tomorrow on one of them. We'll know maybe at the end of August on another. I don't have a date on the Intermediate Court of Appeals with Bombardier. But there's a lot of risk here. And each time that there's a subsequent vote by this council is a further diversion away from what I believe the voters wanted and bargained and brokered for in 2008. There was a lot pitched and sold to the voters in 08 members. This would go to UH Manoa, and you won't need to borrow this money. Everything's going to work out just fine. And here we are saying, no matter what it costs, this is the attitude of I believe this council has been, no matter what it costs, we must build rail because we're in a transportation crisis, members. But there is a better way. It's called the bus. They have municipalities on the mainland that are using fully a fleet that runs on electricity. So it's greener than the rail, superior than the rail. Parsons Brinckerhoff has done studies that the bus beats rail, hands down. Mayor Harris proved that in his study previously. But Act 247 said, you know what, if you make a fair shake at this thing, the bus will again beat rail. That's why they passed Act 247 to say you can't have highway technology. Councilman Kobayashi, you can't leave the fixed guide when you surface streets. Because they knew in Act 247, the legislature, that if they allowed for a fully, the scope to be comparison of all technologies, the bus wins. And here we are trying to mask that with each vote that we take. So the vote today is another perpetuation of masking the truth and the facts. The bus beats rail.
Thank you.
I'm voting no.
Okay.